Hey friends, I'm going to show you a video right after this that I talked to you about a new court case document from Mr. Brian Tuttle. Okay, so you won't see me in the video. I'll be just in the background talking. This is my little intro. Okay, so here we go. Hey friends, welcome to Stocks and Crypto Plays. I'm talking about AMC stock, and we have a new court filing today from Mr. Brian Tuttle. So as you know or may not know, he did a motion to intervene that got rejected by the special master. So he came out with a new court filing today. It says second corrected final motion for declaratory judgment. Okay, so this is the official court document. I just got it today from Brian Tuttle. He sent it to me by email, so I'm sharing it with our team here. I would like to thank him for all his hard work and efforts to help the AMC community. So as you can see right here, we have this document. It says, in the Court of Chancery of the State of Delaware, motion for declaratory relief and brief in support. Brian Tuttle pro se moves this honorable court for declaratory judgment and files this brief in support thereof. Okay, so what I want to point out to you is in here, let's see. Number one, it says, on August 4, 2022, after exhausting AMC's authorized common stock and capital, defendants announced the creation of a preferred stock equity unit special dividend distributed to holders of AMC common stock. Defendants described the preferred stock units as a mirror image of AMC's common stock with identical economic and voting rights. Defendants brief in support of settlement DB at 10,12. Okay. APE's voting rights, conversion rate, and conversion clause automatically converts APE into AMC common, were designed pursuant to DGL 151, never proposed to, let alone authorized by AMC stockholders. Yeah, we didn't approve of this. Okay, it says, by design, the APE special dividend was designed to, let's see, AMC raised $1.8 billion from sales of common stock in 2021. Fox Business Analyst shows company insiders sold $883.5 million of AMC in 2 years thereafter, with defendant Adam Aaron cashing out $101 million of common stock he received from bonuses and executive pay through well-timed and lucrative transactions. C, data shows AMC insiders got rich off retail traders. Number two here says, despite being gravely impacted by the COVID-19 pandemic, let's see, AMC made several acquisitions and investments, which included a stake in gold mining exploration company Highcroft, multiple theaters, and a $25 million commercial starring actress Nicole Kidman. What a waste of money. Let's see. 3, although at odds with public statements of defendants, on July 28, 2022, AMC filed a certificate of designations with the Delaware Secretary of State outlining designations for APE, more specifically in prescribing APE's voting rights to the AMC certificate of designations. Instruct APE shall not be entitled to vote together with common stock with respect to any matter at a meeting of stockholders of the corporation, which under the applicable law or the certificate of incorporation requires a separate class vote. See that right there, friends? APE should not have been allowed to vote with the common stock. It was in the original capital stock documents. All right, let's take a look here what else he has. Defendants adversely altered the voting rights and powers of common by giving APE a special right. On October 4, 2022, defendants entered into agreement with the Computershare Inc. without shareholder approval. Under the accord, the underlying preferred stock used to form APE preferred equity units were deposited with Computershare Inc. and governed by a deposit agreement, the Computershare Depositary Agreement. See that there, friends? I did a video on that when I exposed that to you, friends. Number 5, the Computershare Depositary Agreement instructs Computershare to vote all of the preferred stock in its custody proportionately on non-routine matters and routine matters. In other words, the uninstructed and non-affirmative votes of APE holders can be farmed to be vote at a rate mirroring instructions from participating voters. AMC common stock has no such arrangement with brokers holding common stock. The B section says defendants leverage the computer share depository agreement to rig a vote on conversion of APE into AMC. Number 6. On September 26, 2022, defendants disclosed that they entered into an equity distribution agreement with Citigroup to offer and sell 425 million APE. Plaintiffs brief in support of settlement at PB at 19. Although defendants anticipated that the APE would trade at or around the same price, the preferred stock equity units traded at just a fraction of AMC. Number 7 says, with the expanding trade differential, ID at 13, defendant Adam Aaron urged the pricing committee to lower the $2 minimum price Citibank could distribute APE for at 20. Citigroup obliged. Then, after crashing the price per APE to below $1, introduced defendant Aaron to Antara Capital, Antara, in early December 2022. Once Antara agreed to an underlying to buy and hold APE until after they pledged votes in favor of defendants' proposals, defendant Aaron began working out a deal to ensure Antara a windfall in exchange for a successful proxy vote. The deal eventually closed on December 21, with Antara getting a holiday discount from Mr. Aaron of approximately 0.66 cents an APE per APE. Defendants gifted a rigged vote and AMC common shareholders. Wow. Number 9, cumulative after several transactions with defendants, Antara ended up with approximately 27.8% of the outstanding APE shares, representing approximately 18% of AMC's total voting power. Wow. The hoard of APE held by Antara made the hedge fund, by definition, an interested party. Ultimately, the stockpiled Antara pledged votes were leveraged through the computer share depository agreement to ensure defendants' proposals were locked. Although without either the computer share agreement or Antara deal, defendants could not harvest the required affirmative vote to authorize conversion. You see that there, friends? They couldn't win the vote without the computer share depository agreement and the automatic yes vote. It says it right there. Section 2, AMC common stockholders were damaged by the defendant's breach scheme to circumvent. Okay, let's see how long this is. 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 21. So it goes on for a bit. I don't want to make the video too long. I wonder if I can just, give you the cliff notes of it. So basically, what he's going to say in there, hang on, let me go up. Hang on, guys, hang on. We saw that. We saw the mirror image. Okay. The commingling of AMC and APE votes were in violation of DGL 242. When it came time to solicit a vote on defendants' proposals, defendants yet again disregarded DGL-CL, this time along with their own amendments made to AMC's certificate of designations, which instruct APE holders shall not be entitled to vote together with common stock with respect to any matter at a meeting of the stockholders of the corporation, which under the applicable law or the certificate of incorporation requires a separate class vote. So that's one of the most important things right there. Just maybe highlight that section C, highlight it. You can use that as an argument if you want to use that as an objection in your letter to the judge. You can email that as well. I did a video on where to send the email, all that. If you want to send that to the prosecution, to the lawyers, they can use that as your argument if you want right there. Section C. That's a good one, friends. Okay. So let's see how he ends this. Let's see how Mr. Tuttle ends this. Okay, how does he end it? It's obviously fair to give the affected class a separate vote rather than lump it in with the class benefiting. And he gives some citations there. Let's see. It said, in this case at hand, preferred stock granted a special power through a depository agreement, instructed to vote as one class with common stock that had no such agreement because the NYSE wouldn't allow it. The circumstances surrounding its creation and adoption of the preferred stock command APE and AMC vote separately on proposals that detrimentally affect AMC Common. And he quotes Garfield versus Boxed Inc. And he goes on to say, prayer for declaratory relief in bold. For the above stated reasons, this court should enter a judgment declaring the following. Ooh, I like this. Defendants violated DGL 242 when they designated voting rights to APE without shareholder approval. Number 2, defendants violated DGCL 242 when they designated an automatic conversion clause to APE without shareholder approval. 3, defendants violated DGCL 242 when they entered into the Computershare Inc. depository agreement. 4, defendants violated DGCL 242 when they commingled preferred stock votes with AMC Common. 5, defendants owe to common stock an equitable remedy either through DGCL 204, DGCL 205, or otherwise. Number 6, any other declaration this court finds applicable respectfully submitted. And that looks like Brian Tuttle's signature there. Under there it says Brian Tuttle, pro se, email, and then this document was scanned, contains 2,906 words. All right, Mr. Brian Tuttle, he emailed this to me, so I'm sharing it with you. I do feel honored to have communication directly with Mr. Brian Tuttle. So, wow, what an impressive piece of paperwork. This right here, too, you've got 6 reasons, guys, 6 reasons right here that you can send as an objection, an official objection as to why you do not want the reverse split, as to why you do not want the conversion of AMC into APE, and your objection is to why you think the vote was rigged. You have official wording right here. Now, one thing I want to call out, be careful with the word depository. It may just be a typo in number 3 there. It says depository. There's 2 very tricky words that are very similar, depository and depositary, okay? And they mean 2 different things. It could just be a typo. Computershare is the depositary. And so let's see if he says it up higher in here. Depositary. Let me go back up here, friends. Okay. Do I see the word depositary anywhere? It's really tricky, that those 2 words, because they sound so very similar. Yeah, see it there, guys? Number 5. The Computershare depositary agreement instructs. You see it says depositary with an A. And then down here, Mr. Tuttle accidentally wrote depository. See line 3? Into the Computershare Inc. depository agreement. It should say depositary. So if you're going to use these as an outline where you're going to send them to the judge and say, hey, these are my complaints, although the judge said you can only make 1 complaint, so maybe you want to pick 1 out of here and say why you object to this reverse split. Make sure you say depositary. Don't write depository, because they're two different things. And it is very easy to mess up. You know, I'm pointing that out for that reason, okay, friends? But I would like to thank Mr. Brian Tuttle, super intelligent man. Obviously, I thought he had lawyers write this up. That's how good this is. But he's representing himself. Clearly, he's very talented. So thank you, Mr. Tuttle. And I think we should all be truly grateful to him. So this is his newest court document as of today. Second corrected final motion for declaratory judgment, okay? I appreciate you all. Hit like, subscribe, and notifications. Share the video with a friend. Comment below. What do you think about all this? I'll talk to you soon. Have a great day.